EMV 21009. We are representing plaintiff case of Al Shaddock and Associates Private Limited versus Paramatta City Council, 1981. Al Shaddock and Associates Private Limited related and Paramatta City Council would consider the purchase of a property in Paramatta for the purpose of renewable development. On 10th May 1991, Al Shaddock and Associates Private Limited contacted the relevant department of Paramatta City Council and inquired that if any road widening might affect the property. He was advised that there were not. It is not required by legislation to advise whether there were any such road widening proposals. It was the Council's practice to do by endorsing the statutory certificates it provided with a statement that in read road widening or reclining proposal was in existence. The statutory certificate provided by Council dated on 25th May 1973 in relation to the property did not contain any such endorsement. In other words, the Council was silent to the return request. Al Shaddock and Associates Private Limited informed about the road widening proposal affected the property. A local road widening proposal that would affect the property being approved in principle by Council in 1971. By May 1973, the details of the road widening proposal were in question, but there were no doubt that it would be adopted. On 21st May 1973, Shaddock and Associates Private Limited entered to a contract to purchase the property. The purchase was completed on 7th July 1973. The road widening proposal was formally approved by the Council in February 1974. It had a proposal to acquire compulsory one-third of the land of road widening of Al Shaddock Private Limited, Al Shaddock and Associates Private Limited. Therefore, the demand was unsuitable for Al Shaddock's and Private Limited.
Hi, Mr. EMB 20699. I am dealing with rules applicable for these kinds of cases. First of all, we need to know about negligence. Negligence is a failure to exercise reasonable care and skill as a result of a person suffers damages. Plaintiff can ask for damages in these conditions. Number 1, the defendant has obligations to provide them a duty of care. 2, the defendant has breached the duty of care. 3, plaintiff suffered damages as a result of the breach.
Hello, I am Bir Subhagurum, student ID EMV 3429, and I am going to discuss about the application of this case that happened in this scenario. In 1973, when Shaddock wanted to purchase the land, then the representative of company, Mr. Carroll, approached to the council via orally inquiry. Mr. Carroll took steps to establish whether the local council had any intention to widen or realign any of the various roads nearby. He telephoned the council and asked an unidentified employee whether there were any such proposal in existence. The employee said there were not. In this case, council owed no duty of care in answering that inquiry. The answer is not confirmed in writing. The provider of information remained unidentified. The High Court had no doubt that the oral inquiry was insufficient to create a special relationship between the plaintiff and defendant. However, both Stephen and Murphy JJ suggested that rarely would a duty of care exist in such circumstances, particularly when there was a formal means of obtaining the information. However, an oral inquiry may in some circumstances raise a duty of care. Secondly, the council argued that it could not be liable for negligible misstatement in failing to note the road widening proposal on the section 342 AS certificate because no statement as such was made. The court accepted this, holding that one could not be liable whether the supply of information is made by implication, but Gibbs drew an analogy with evidence cases in which it had been suggested that where a reply to correspondence is expected, a failing to reply is tantamount to evidence of truth of the statement contained therein. In the light of past conduct in answering inquiry by endorsing the Section 342 AS certificate, the failure to answer amounted to an information of fact. There was no duty on the council to answer, but this was irrelevant. This case established that liability for negligent misstatement will arise where the government authority ought to have known that the person seeking the information would rely on that information and could suffer loss if the information was incorrect. Government bodies which provide information for tender submission must make sure that all the such information is as accurate as possible. Failure to do so in the absence of an appropriate disclaimer could lead to liability for negligent misstatement. This duty to ensure that information is accurate extends to all dealing with which governmental authorities have with the public.
It's me, Dilaram Kandel, and my student ID is EFA20171. I'm going to talk about the decision of this case. The High Court of Australia take a decision with on the base of case Mutual Life and Citizen Assurance Company Limited versus EVAD, which was in 1968. And on that case, the court also agreed that liability for negligent misstatement was confident of those who carry or not or on or purpose to carry on profession, business or occupation involving in the giving advice according to safe justice give us at 391. There is no valid ground on which is distinguished between information and advice for the purpose of a rule in Hadley Band. Through that, giving the advice must always necessary to require exercise of or skill judgment, and the giving of the information may not necessarily do so. A person giving information may be so placed the others can responsibly rely on this ability carefully assertions and the importance information. Justice motions at 404 adopted the statement of the Chief Justice Brockwell Mutual Life Citizen Assurance Company Limited, EVAT 1968, 122 CLR 556. That decision was made on the basis of this case.
My name is Sasan Sakya and my student ID number is AZZ2013. So I'm going to conclude about this case. So talking about the conclusion, High Court decided in favor of plaintiff. Counsel had breached its duty and was therefore liable to compensate the plaintiff. Thank you. That's all about the case.
Thank you.